And instead of taking my Lord's time on all this, they affirm whatever.
What is the full name of the case, please?
I'll list it.
You just write it down.
Yes, yes. My Lord Star, I'll list it. Yes, my Lord, it is. Yes, it is my Lord Sunrise Associates.
Sunrise Associates is first.
Yes, Sunrise Associates. This versus Government of NCT of Delhi and others.
Yes.
And my lords, they go into the Justice Tulsapurkar's thing of splitting it and showing it's only a right to participate and all. They said don't split all that. Otherwise, the SSCs were in difficulty. They said it's one unbreakable right and it amounts to a transfer of actionable claim. And they use
that is what we have said in Meghalaya also.
Yes, my lords have said that. So therefore, this dichotomy saying that there is a transaction.
What are the paragraphs in Sunrise?
Sunrise, my lords, para 40 at page 585.
And we have also said in State of Meghalaya.
Yes, absolutely, my lords. And para 50,
State of Karnataka versus State of.
So therefore, at para 40, my lord, shown of all the other details where they affirm, they say there is only one right. It's both transfer of an actionable claim, and they say it's a transfer of an actionable claim. As I said at para 40, they say, in our opinion, a sale of a lottery ticket also amounts to a transfer of an actionable claim. Last two lines, my lords, in para 40. And at para 51, they finally conclude. We are therefore of the view, decision in Anraj incorrectly held that the sale of a lottery ticket involved a sale of goods. There is no sale of goods within the meaning of Sales Tax Act of the different state, but at the highest, a transfer of an actionable claim. So there is nothing stepping in between saying whether I'm a stockist or anything. And as I said, my lord, I asked my clients, is there any restriction for you to participate in the draw itself? There is none. So the transaction which is taking place is a transaction in actionable claim, whether I am selling it or the state government is selling to me.
Yes.
Lordship,
that's all.
Then, my lords, just sorry, just one. I'll just give the. Now, my lords, I'll mention it and I'll also put it in my note. So, my lords, when we went on challenging these provisions in 2015, they made an amendment saying earlier it was consideration is what any person pays to the service provider, right, my lords? And there should be an amount charged, which my learned friend Mr. Ganesh had said there should be an amount charged. We have one ruling for that. Charge means there must be an invoice raised, etc. Just give that. Supreme Court decision. Gajanan, give that at para 6. We're only supplementing what Mr. Ganesh argued by a judgment. In para 6 matters. So far as the first argument is concerned, we do not find much substance in it. The term charge is a broad one, as used here. It's not a technical term. It has not been defined by the Act. It is therefore its ordinary dictionary meaning. It means any amount which may be demanded as a price for the rendering of some service or a price of some goods. Lordship has seen that in para 6. Service it is not. They are demanding it as a price of the goods. There is nothing being charged for any service.
Paragraph?
Paragraph 6, my lords.
Yes.
So it means any amount which may be demanded as a price. I can demand nothing because I am not issuing any kind of service. My lords, if I was rendering service, I have to demand. In this case, my lords, as I say, it's all ulti ganga. The state is demanding from me. I don't get any penny. So where is the question of any service being rendered? I can't demand anything. This is how it's traveling. I'm only a paying party. Then, my lords, what they did, my learned friend didn't get into that. But in 2015, for the definition of consideration, they expanded it. This is, my lords, in his volume 1, page 212. The gist of it is, now they put an explanation for consideration.
Yes.
And by that they define consideration to mean, I'm sorry. Yes. Now the defined, my lords, at 209-2010 in his volume, consideration includes any amount that is payable for the taxable services provided or to be provided, any reimbursable expenditure or cost incurred by the service provider, my lords, that we fought a battle and ultimately we won in Supreme Court. Now they introduced any reimbursable expenditure. I, as a lawyer rendering a service, I take a flight ticket, I charge him. Earlier we said you can't include it, it's not a consideration for the service. They said any reimbursable expenditure you'll add, not a problem. Any amount retained by the lottery distributor or selling agent from gross sale of lottery ticket in addition to the fee or commission, if any, or as the case may be the discount received. That's the difference between the face value of lottery ticket and the price at which the lottery distributor or selling agent gets it.
That's your margin.
That is your margin.
So on that,
So therefore now they amended it saying this will be the consideration.
yes,
My lords, the only flaw in such a provision is that actually there is no consideration which is flowing. And you take,
if it is a difference in the margin, that margin,
yes,
where is the commission then?
there is no commission. They treat that as a consideration for my service. There is a service being rendered first. You go one step further and make an explanation and say, I will take the discount. First they take face value minus the price at which I get, that will be the value. From where? Or the difference between price at which I get and the price at which I am selling, or any fee or commission. Fee or commission, my goose is cooked if there is a fee or commission. But how do they make
That will be liable for income tax. The margin will be liable for income tax.
Yes, margin, definitely. And that fee or commission will be liable also to pay income tax. But here is a question of buying and selling. You introduce an explanation like this, and the High Court struck it down, my lord, saying that the
You are
explanation,
challenged all these.
I have challenged. Explanation is going much beyond the main provision. Main provision talks about consideration. For a consideration money be the gross amount charged. You are putting in an explanation and all fancy computations, my lords. And only in that context, there is one judgment of this honorable court, my lords, where they said the value cannot be so fancy.
The High Court judgment is very lengthy, I found. Over 200 pages of this SLP.
No, but it did trouble them, my lords, because they have to handle the constitutional entries and all those decisions, RMDC, I'll just point out those. That's all we cited, and that is how they went into it. And explanation, my lords, cannot be substantive. There are a couple of decisions. I'll give the citation and we'll put that. That is the, my lord, the Hardev Transport and Sundaram Pillai.
Yes.
Famous ones. I'll put them in my written submissions. I'm not troubling my lords.
Explanation cannot also be contrary to the main provision.
And it can't be substantive.
Yes.
It can't be a substantive provision for the first time. You start bringing it through an explanation. Right, my lords? And then Rajasthan State Chemist, there is a decision. I'll just summarize the decision. My lords, under sales tax, suddenly the sales tax department said, we'll take the MRP value. Like in Central Excise they're doing, we'll take the MRP value as the value of your sale price and charge sales tax on that. That their lordship said, nothing doing. Saying it cannot, my lords, at paras 28 and 50 in this. Where is judgment?
Paragraphs?
Yes, my lords, paras 28 and 50 in this. This is precise judgment. That a value cannot be so removed Yes, para 28 minutes. The question of tax
Yes.
and sale of goods may be examined in the above background. The subject of tax being sale, measure of tax for the purpose of quantification must retain some nexus with the sale, which is subject of tax. As noticed above, tax on sale of goods is a tax on the vendor in respect of sales and is substantially a tax on sale price. The vendor or purchaser or buyer cannot be taxed, deholds the subject of tax, that is sale by the vendor or purchaser by the buyer. The four essential ingredients of any transaction of sale of goods include the price of the goods sold. Therefore, in any taxing event, sale which becomes the subject matter of tax price component of such sale is an essential part of the taxing event. Therefore, the question does arise whether for a particular taxing event of sale could be subjected to tax at the prescribed rate to be measured with such price, which is not the component of the transaction of sale. With such price, they want to take the MRP. And at para 50, they said, no, you can't do it. However, why do you want to have the value of a particular transaction? It can't be absolutely without any relationship. Which is para 50 minutes. Applying the principles enunciated above, the inevitable conclusion is that when the wholesaler sells any formulation to a retailer in bulk quantity, taxable event of sale of goods takes place by the wholesaler and retailers or the parties to the contract. The goods in question are the formulations, and the consideration is one which is agreed to between the parties to the transaction, within the limits permissible by law. By substituting the assumed quantity of goods or a price which is not the subject matter of that contract of completed sale for the purpose of measuring tax, legislature assumes existence of a contract of sale of goods by legal fiction which has not taken place and which cannot be considered to be a sale in the manner stated in the Sales Tax Acts, which alone can be the subject matter of sale of tax under entry 52. Substitution of assumed price or the assumed quantity in place of actual price quantity in a completed sale transaction for the purposes of levy of tax on the subject matter of tax results in taking away from it the character of sale of goods as initiated in the Sales Tax Act. So ultimately here, if you suddenly say, I'll take your discount as the consideration for rendering service, where are they going, my lords? In a buying and selling? So this judgment, my lords, was one which we found because generally the courts have been uniform in not touching the value. They say taxable event, after that you take any, Bombay Tire we lost. They say take any value. But that has to have some nexus, man. It can't be like this. But suddenly I say your discount is your consideration in the case of a sale transaction.
Yes.
Right. Then,
Which is the next point?
yes,
Anything else left?
one, I'll just finish. Then, my lords, I come to this aspect theory.
Aspect theory. Where now in this matter?
Uh,
What Mr. Ganesh argued is you are anyway paying under entry 62.
yes. So, entry,
Yes, you are admitting that.
therefore, today, my lords, when they want to tax me, they are talking about, my lords, 4 elements. If you see the 2010 amendment, they say promotion, marketing, organizing, assisting in organizing. Right?
That is all service, according to them.
They say these 4 things you're doing, therefore your neck is in the noose. But
What is that? Promotion?
promotion, marketing, organizing, assisting in organizing. Right, my lords?
In organizing?
Answer. Organizing and assisting in organizing.
Assisting in organizing and organizing.
Lordship. Right, my lords?
Hmm.
Now, my lords, I can only put my lord's judgment only. I don't have to go further than that. As far as organizing and conducting, my lords have held in my lord's judgment. My lords, that is in which volume?
Meghalaya.
Meghalaya is in his volume. Which volume?
Paragraph you just tell us.
My lords, paragraph, my lords, 158.1, 159.2, volume.
Hmm.
And paragraph 159.3 and 159.6. Lords, this is in volume 2, page 589 onwards. And these pages, my lords, would find at 665, 666. And there, my lords have held, all this organizing, conducting, everything falls under entry 62.
Yes.
Right, my lords? Now I'm only left with promotion and marketing. Now, my lords, right from RMDC Chamar Bhagwan, with the judgment, there the promoter, in fact, it's the same argument which my learned friend is taking. There the promoter came and said, look, I'm only promoting, I'm not betting and gambling. The lordship said, forget about it. The entry is very wide. Any I will not say aspect, but not all activities under that would fall under 62. Lordship sees in my lords in para 6.
Yes. There are 2 RMDCs, no, actually.
Yes, there are 2.
In Dio.
We are on the first one, my lords. This is a constitution bench again. My lords, at para 6.
Rajula Naidu is the advocate general.
Lordship, yes.
The leader of the
Actually, it takes you back to so many memories when you were there with these people. my lords.
Yes. He was a very, very strong advocate general and who used to claim that he was a leader of 2 bars. One is the bar, that is the advocates, and the other bar.
Yes. But some of them are larger than life.
Yes, yes. It was a very powerful, very strong advocate general.
So para 6, my lords, was the para 6. November 20, 1952, State of Bombay passed.
Huh? My learned brother is saying there was no reaction from this bar, from here. Huh? Yes, spirited advocacy.
It's here. Lordship sees, I'm sorry, there's no placid term, otherwise I would.
Which paragraph?
Para 6, my lord sees.
Yes.
So, my lords, on November 20th, so and so, State of Bombay passed this act, my lords. This act amended the provisions of the 1948 Act in several particulars. Thus, the words, but does not include a price competition contained in a newspaper printed and published outside the province of Bombay, which occurred in the definition of price competition in section so and so, were deleted. And the effect of the deletion was
Promoter. Definition of promoter.
promoter. That's right. Amending Act introduced a new clause which defined the words promoter. Then my lord sees directly. So the argument of the SSEs was, look, I'm only a promoter. I'm not doing betting and gambling. Lordship comes to page 2, para 22. My lords.
Yes.
The next point, my lords, para 22, that although the Act may come under entry 34, taxing provisions of section 12A cannot be said to impose a tax on betting and gambling, but imposes a tax on trade under entry 16. Once it's held that the impugned act is on the topic of betting and gambling under entry 34, tax imposed by such a statute one would think would be a tax on betting and gambling. Appeal court has expressed the view that section 12A does not fall within entry 62, for it does not impose a tax on